Hi, my name is Marty Shankman. This is Elvis, and this is a video series entitled Elvis Does Estate Planning. Hi, my name is Marty Shankman, and this is Elvis, and this is a video series entitled Elvis Does Estate Planning. This particular segment is entitled Planning Your Will. Our goal is to give you practical, useful information to help you better utilize the services of your attorney and your estate planners in getting your estate plan done, and hopefully to give you information that's much more practical than some of the trite data that's typically given to consumers. For more information and a wealth of, this is an interesting topic, Elvis, sit still, a wealth of sample forms and a lot of sample, okay, I'll tell them in a minute, but we'll put you down. Elvis wanted me to remind you that there's an opportunity to ask Q&As, questions and answers, and there's a lot of existing ones on the Law Easy website that may answer a lot of your questions, and you can search them. Let's get back and talk about the topic of this video, which is your will. The biggest problem that most people have is they assume that when they talk about estate planning, they're talking about doing a will. A will is only a very small part and often not the most important part of your estate plan. We had another video where we talked about durable powers of attorney. The durable power of attorney is a document which gives an agent that you name the authority to make gifts and other transfers and handle financial, legal, and tax matters. Some agents are given enough authority to give away your entire estate. So don't get focused that the will is the only critical step of an estate plan. In many cases, it's far from it, and we'll give you some more reasons why as we go through this. The next big mistake people make when they talk and think about a will is they think they go to a lawyer, tell the lawyer what they want, the lawyer drafts a will. That's important, that's a big part of it, but you can't draft a will that works until you first plan a will that works. What do I mean? First of all, what are your assets? If you have a house and it's owned jointly with your partner, your spouse, or a child, when you die, that house is not going to be governed by your will. It's not going to go through the process called probate, which is not the terrible evil many people make, and we have another video on that. Your house is going to go as the deed says. If you have an IRA or a retirement plan and you have a designated beneficiary, which you definitely want from an income tax planning perspective, that designated beneficiary is going to get your retirement plan or your IRA. Your will's not going to govern it in most cases, and you don't want to have your retirement plan in most, not all, but in most cases payable to your estate, because it often will result in a more rapid payout, which is a negative from an income tax perspective. So what about your brokerage account or your life insurance? Some brokerage accounts are set up with a designated beneficiary. Most life insurance policies have a designated beneficiary or are owned by a trust, and we have a separate video on that. So what's the point of this and how does it relate to your will? Unless you first plan what your will is going to do, you may not have any assets governed by your will. The vast majority of Americans have a very substantial part of their estate that never is governed by their will. Joint bank accounts, house owned on a deed as joint tenants with a spouse or somebody else, pay on death accounts at the local bank, insurance policy with a designated beneficiary. So you got to plan your estate even before you get to the will to know what your will does. Let's go to our next slide and we'll talk more about some of the key will decisions. When you start to take a look at your will, again, be very careful to understand what your goals are, what you're trying to do. Another key step is to find out and determine, do you have tax obligations? If your estate is small enough, you may not have any state or federal tax obligations whatsoever. It may also depend on your heirs. Some states have estate taxes, some states have inheritance taxes. You need to talk to an estate planner in your state and find out what you're facing so you can determine if there's any planning that should be done to minimize, it's usually not eliminate, but minimize those taxes. And in many cases, people will try to minimize or eliminate the federal tax, but starting in the year 2009, you can give away $3.5 million without any federal estate tax. So federal estate tax is really something that probably only affects 1% of the population. So for most people, it's not the key issue. For those that are affected, it's a critical issue and something that requires an awful lot of planning. And we'll talk about some of the techniques and some of the other video presentations on QPRITs and GRATs and other more sophisticated planning techniques. Let's go back to the will. So now you've figured out what assets are subject to the will, you've come up with a plan, you've considered your tax issues. What's next? How do you want to leave assets and who do you want to leave them to? It doesn't take a lot of creativity if you're married with kids to say, I'll leave my spouse my assets, and when my spouse dies, he or she will leave them to the kids equally, end the discussion, and if a kid's under 21, it'll be held in trust. That's way too simplistic for the complexity that faces most families. First of all, whether the statistic is correct or not correct, that 50% of families are divorced, I think it's 75% of second or later marriages end in divorce. The statistics don't reflect the percentage of the population that has partners or non-married significant others. So frankly, for most people, that simplistic view of what estate planning is about is probably only useful for the Cleaver family, and as I recall, that was not a reality TV show. So you really need to get a little more real about what it is you want to do, who you want to benefit, and how to go about it. So if you're going to have a spouse or a partner get assets, but you may have children from another marriage or other people getting them after he or she passes away, you probably want to use what's called a trust. A trust is a contractual arrangement which can be independent of a will or created under your will, where you name a specific person, a trustee, it's a fiduciary, someone in a position of trust, to manage those assets for your spouse or children. So if you're in your third marriage and you want to leave your assets in part to your spouse to assure him or her of certain cash flow during his or her lifetime, and when he or she dies, leave them to the children, a trust is probably the way to go. And it gets much more sophisticated and complicated from that. One of the other issues that's important for you to really do a little soul searching and think about is it's very easy to say, as I did when I did my Cleaver family estate plan, we'll leave everything equally to the kids. Is equal equitable? And whether it's children or nieces, nephews, friends, whoever you're leaving it to, is equal equitable? How do you really want to help those people? Right now in 2009, we're going through one of the most difficult economic times in history. One of your children may be fully employed, they may be struggling a bit, but they may retain their job, their house may be under control, everything may be fine, where another one of your heirs may have in fact lost his or her job, have their house foreclosed upon, and really be up a creek without the proverbial paddle. So if you die, is leaving everything 50-50 between those two kids or cousins or whatever the heirs are? Is that really what you want? There's several approaches. You could leave more to one, 60% to one child, 40% to another. You could leave 30% to each child, and then leave 40% in what we could call a pot trust, a trust that could benefit either or both. You might provide them when the youngest child attains age 35, the trust is divided equally. That may give the trustees some time to help both of the children how they need, for their needs, get back on their feet. So there's a lot of different ways with a little bit of creativity and not a lot of cost that you can make your will much more compassionate, much more tailored to really accomplish the goals you want. But the first step in that process is to get beyond, oh, I want everything equal. That may be what you want, but ask yourself if it is really what you want. And maybe the simple concept of a pot trust to let somebody have some hindsight, some flexibility after the fact, after you die, to divvy up money in a way you really want might be much more productive. Another very important, really important part of a will is if you have minor children, you need to name a guardian. We have another video clip where we're talking about caring for your children. We have another video clip where we talk about fiduciaries that addresses this issue in some greater depth. But at this point, just suffice to say, in your will, you also need to name a number of fiduciaries. And we've really kind of talked about them, but let me summarize them again here and point out the interrelationship between them. The person that's going to manage your estate when you die, collect all your assets, pay your bills, pay your taxes, if any, and then distribute assets to your heirs, as you've directed, is called an executor or personal representative. The person that may manage this trust that we spoke about, and we gave a couple of examples for a spouse, a pot trust for children, and those are just two of very many examples, is called a trustee. The third fiduciary is a guardian for your minor children, and that could be a guardian of the person or the property or both for your minor children. If you set up a trust for your children, and we talked briefly about that, the guardian then will be in charge of the child as a person, but not have full unfettered control over the money. And that's a good check and balance to institute. So when you go through the process, you want to name the various fiduciaries. You want to consider how you're distributing money. There's lots of ways to do that. We have another whole video segment just on how you can distribute and allocate your wealth, because there's so many different variations. And the key is really to pick what works for you and achieves your goals. And finally, just to recap and close, a will is a critical part of your estate plan. Even if you're going to rely on a revocable living trust, and we have another video segment on that, you still need a will. It'll be called a pour-over will, and it'll probably pour assets into your revocable trust, but in many cases you may want a complete will that addresses all the issues as well. You need to look at your overall plan and see what assets are governed by your will, because otherwise your will may be a great document, do everything you want, but nothing gets subject to it. You want to take a look with some care and thought about how you distribute assets and who you name as your fiduciaries. Thank you for joining us.